Thank you, sorry about that.
Okay, good. I decided to count the meeting in open session. Can't do executive session, but open session seemed like the proper way to go. And just to mention to everybody, in a conversation with our borough attorney this morning, Clerk Thompson and I talked about a letter asking for an extension or a delay on this process, and the attorney said just to proceed. So that being said, we're going to go down the order of presentation. That's, we all have a copy of that, but the first person to present is the building official. So Mr. Bergnoli.
Actually, that'll be Director Hagerman is filling in for the building official title today.
Oh, okay. Well, I guess it would have been nice to have the names, but okay, Mr. Hagerman.
Thank you, Mr. Mayor. So today we're here to talk about the appeal of the notice and order abatement for 410 Mitkof Highway owned by Ms. Courtney Johnson. On July 24th, Officers Walker and Pop were at the residence 410 Mitkof Highway in order to seek a subject with an active felony warrant. The owner of the home, Courtney Johnson, gave permission for the search of the home for that purpose. And during the search, Officer Walker was on the deck of the home and saw an issue with a sewer spill, including human feces on the ground outside. He took a photo, and after he was done with his business on that day, he forwarded those photos to the building official of the borough, the wastewater department, and I received copies of the photos afterwards. I'm just going to ask Officer Walker real quick, does that comprise your activities on that day, and do you have anything else to add?
That about sums it up. While we were there, we were looking for somebody with a warrant, stepped out on the back porch to just look out down the hillside, and I mean, as soon as we stepped out onto the back porch, we looked down, and there was just a pile of human waste and toilet paper sitting there. And I took a picture of it since it was in plain view where we were legally allowed to be, and forwarded those on to the proper parties. Okay.
Thank you, Officer Walker. So once the issue was known, I first tried to contact the owner of the residence during the lead up to the issuance of the notice and order of abatement by calling all the numbers that I had available to me to make that connection. The numbers were either disconnected or not working. So due to the seriousness of the issue and the fact that there had been a previous issue at this address with an intentional tampering of a water meter in 2019, I decided to proceed with the notice and order of abatement on the sewer issue. I issued the notice and order of abatement on August 3rd, 2020. A full copy of that notice is attached to the meeting packet today. The notice and order was served to her home by me on August 3rd at 5 p.m. and left on the front door after repeated knocks at the door went unanswered. The notice and order was also sent to Ms. Johnson via regular mail and certified mail. A copy of the return receipt is part of the appeal packet. The order of abatement is in regard to the public nuisance that has been allowed to occur by the property owner. The nuisance itself is a raw sewage spill below the home in question on the hillside that leads to the beach of Wrangell Narrows, a state water body afforded protections under the Clean Water Act. The residence is within 150 feet of the borough sewer system and is therefore required to hook up to our collection system, our wastewater collection system. The description of the nuisance in the order of abatement reads as follows. Raw sewage, including human excrement, is being discharged from the household onto the hillside and beach of the Wrangell Narrows without treatment. There exists a sanitary sewer service lateral pipe which the home must connect to per municipal code. That was a statement in the order. In reviewing the municipal code violations that come into play here, we look at Chapter 1408-020, unlawful sewage disposal methods designated, which states under A, citizens cannot deposit human waste on public or private property, and B, no discharge of untreated sanitary sewage to a natural outlet is allowed. Also, Chapter 1408-080, when connection to public sewer is required states under A, if a public sewer is within 150 feet of a property, the owner must connect to the public system within 180 days of notice to do so. Under B, states that septic tanks must be abandoned, pumped out, and filled with sand to decommission them. And C, if an owner fails to connect to the public system, they will be charged for sewer service and ADEC will be notified. Under Chapter 9.16, titled Nuisances, specifically 9.16.1 or 030, unlawful enumeration. Under A, it is unlawful to create, permit, or maintain a nuisance. And B, nuisances are defined in this section as, under number 2, unlawful to deposit or allow existence or presence of human excrement on waste or waste on the ground. And finally, Chapter 1404.130, unsafe facilities. The Borough Water Department may disconnect water service to any premises where plumbing facilities are dangerous, unsafe, or non-conforming to federal, state, or local laws. The corrective actions that were stated in the order include the area of the spill was to be cordoned off so that no persons or pets could access the site of the spill. Also, the sanitary sewer of the home was to be connected to the borough's wastewater collection system. That any contractor that was hired to make the connection to the borough system must be licensed and all work must be inspected by the borough before backfilling. And the area of the spill will need to be cleaned up per DEC guidelines, which were attached to the order. The deadline for corrective actions was set to be August 18th, which gave the owner 15 days to comply, and the nuisance appeal process was also outlined. Ms. Johnson filed an appeal as allowed under the nuisance code on August 18th and indicated that she was working on a fix to the situation. Brooke Thompson worked with Ms. Johnson to schedule an inspection at the site. On August 24th at 2 p.m., Joe Bergnoli, building official, Justin Haley, the wastewater operations supervisor, Dennis Jones, a wastewater operator, Officer Walker, and Chief Kerr paid a visit to the residence to perform the inspection of the repairs. On August 25th, Joe Bergnoli and Justin Haley both supplied inspection reports via email to the borough manager, and both of those reports are part of the hearing packet. Mr. Haley reported that contact was made with the homeowner and a helper, and the repairs were discussed. A tour of the repairs included a reestablished connection to the septic tank, corrugated piping and a discharge from the septic tank to a nearby creek. At this point, I'd like to ask Justin Haley to elaborate on the findings that he came across on that day and elaborate on anything that I missed.
We got there, met with the homeowner, and friend of hers that had helped her kind of fix her problem the way they saw it. And we discussed a few things. They explained that they had run a discharge to that nearby creek from their old septic tank, and talked about how that really wasn't appropriate and kind of violated every regulation that I knew of. We went around and inspected the line from the house to the septic tank, which is the septic tank's about 40 feet down the hill from the house, 30 to 40 feet. It's quite a descent, and they'd used corrugated plastic pipe, which is more suitable for area drain in a yard, but it's not acceptable for sewage. And that also downsized from a 4-inch leaving the house to roughly 3-inch drain pipe. That's not acceptable either. It just sat over the ground going down the cliff to that septic tank. Dennis and I went down the hill and checked out the septic tank, and the drain line they'd installed to carry away from the septic tank into the creek, and none of that really met any of the regulations, the codes that people would usually follow when they install a sewer line. The septic tank clearly hadn't been even checked to see if it was functional. It had substantial growth on it. Probably hadn't been into in many years. Yeah, we explained that, you know, anything they've done to that point is better than just spilling it down the hillside, but it was far from the correct fix, and that they would need to eventually, as soon as possible, connect to the borough sewer. And it was about as far as we really got productively through that inspection.
Thank you. Thank you, Mr. Haley. So just to recap, so that even though the sewer was connected to a septic tank, there was no sign that the septic tank has been pumped recently, in fact, probably for many years, and that it was functional. Is that correct?
Correct, yeah.
And the discharge from that septic tank was also laid across the top of the ground and discharged into a open stream?
Yes.
Okay. Thank you. Moving on to Joe Bergnoli's inspection report. Mr. Bergnoli approached this inspection from a building official standpoint, of course, and mentioned in his report subpar materials and methods of connection. Mr. Bergnoli, can you paraphrase your findings from that day in relation to the materials?
Right. Well, I was just, as I said, that's the stance I took. I was going to find out how they connected it, and Mr. Haley pretty much reiterated all the code violations that I noticed there, starting with basically when they made the transition from the existing cast iron sewer that comes out of the house to going to plastic, and then downsizing a size which you can't do. You can't downsize in the direction of flow. And then they transitioned again to that corrugated pipe, and which, as Mr. Haley says, corrugated pipe is illegal in sewer applications. And the connections they made, tried putting these together. Obviously, it's the fittings that you can't. So the fittings were all wrong too. So basically, those are the big things that I noticed. I did not go down the hill to the septic tank. That was a young man's sport. That was traversing down the hill. That was kind of sketchy at best. But yeah, those guys went to the septic tank. But I stayed on top with the officers and just observed what I could from the connections in the pipe. So that's pretty much the long and short of it. And when I talking to the helper, it was made clear that we just did this as a temporary fix. So we weren't spilling down the hillside, which obviously was better. But they were informed, and they did verify that what we were saying, that this pipe cannot stay as it has been installed now. And they're agreeable to that. They're made aware of it anyway at that time, that this temporary fix was not a solution.
Thank you, Mr. Bergnoli. I'd like to point out to the assembly that in the packet there are 3 photos from that day of the inspection showing the various piping that connected the old septic tank to the home and the discharge to the stream. Then moving on, Mr. Haley also had a conversation on the following day on August 25th with Raymond Zimmer, who represents the Alaska Department of Environmental Conservation, in regard to the state's position on acceptability of a septic tank in close proximity to the public sewer system. Essentially, Mr. Zimmer informed Mr. Haley that septic tanks were allowed at one time in the state, but must be upgraded if they ever failed, which appears that this tank did probably years ago due to lack of maintenance. Also that to upgrade the system for marine outfall, that secondary treatment and disinfection would be part of a treatment package for the home, and that DEC recommends that if septic tanks do fail and public sewer is available, that homeowners should connect. and that goes along with the borough's code as well. Just ask Mr. Haley if that represents your discussion with Mr. Timmer, and if I missed anything on those points.
Yeah, that pretty well covers it.
Okay, thank you. Now I'd just like to go down a list of statements that were made by Ms. Johnson in her appeal application and provide some information to the Assembly. Ms. Johnson says that she was unaware that she was violating any wastewater codes. It took Officer Wachter just a glance from the deck of the home to see sewage on the hillside. The pipe is right at the base of the home's foundation, and the photos of the spill do not indicate any overgrowth that would have hidden the situation from the homeowner or other tenants. The assertion of a lack of knowledge is not credible, in my opinion. There is considerable verbiage in Ms. Johnson's appeal regarding the borough's responsibility to monitor a home sale and require that utility systems are legal, that occupancy is allowable. It is not the borough's responsibility to ensure that all codes are addressed when a home is sold. The buyer and seller work out those issues and are responsible to ensure that all code provisions are met. The borough does not issue a certificate of occupancy for home sales. The prior owners, the Lane family, were sent letters requiring connection to the public sewer system in the past. They had been billed for sewer as required by the code for many years, and the borough was not aware that a connection to the sewer system had not been made. Ms. Johnson says that she didn't think septic systems were legal in 2020, and that she believed the house was connected to the public system. Again, a home inspection was her responsibility, not the borough's. Ultimately, her belief is not relevant, and the house must be connected to the sewer system. Spillage of human waste on her property is not safe and not permitted. She implies the borough should bring homes up to code when they are bought and sold. Again, it is clearly up to the buyer and seller to ensure that homes meet applicable codes. Ms. Johnson mentioned the time earlier in the summer when 5 city workers and an officer visited her home and performed a thorough inspection in regard to a prior report of sewage spill in the area. Mr. Haley can confirm that this inspection took place and nothing was found. But I believe that during that inspection, the area under question in the July spill was not viewed. No unlawful search occurred on July 24th, and no one's privacy was violated. Officers Walker and Pop had permission from Ms. Johnson to enter and search the home, and feces were in plain view. Ms. Johnson questions the legality of the abatement order delivery. The notice and order of abatement was served on the property by myself, a borough department head, on August 3rd at 5 p.m. It was left at the door after several attempts to knock and raise someone to the door were unsuccessful. A photo of the order packet on our front door is included in the hearing packet. Additionally, a copy was sent by regular mail, and a third copy sent via certified mail. The return receipt is also included in the hearing packet. She obviously received the abatement order and packet of information since she filed this appeal. There's been no denial of the sewage spill that is the impetus of this entire proceeding. The photos July 24th clearly show a violation of the municipal code in regard to sewage being deposited on the ground. The inspection reports and photos from August also show that there remain significant issues with the sewage system at the home. Ms. Johnson says she is willing to fix the problem after getting additional information from the borough. My recommendations at this point to the Assembly, after reviewing the original information received, the notice and order of abatement, the inspection notes, and communication with DEC on this matter, I recommend to uphold the order of abatement about August 3rd. The homeowner has shown no compelling reason that would allow the continuation of an untreated sewer discharge onto the ground from her home. The existence of an old septic tank does not change the fact that the public system is available for her to connect to. This will require installation of a small residential pump station and connection to the borough system. Continuing to discharge untreated waste from the old failed septic tank to a stream is in violation of local, state, and federal environmental laws and cannot continue. The excavation and connection should be completed by a licensed contractor and all connections inspected by the borough prior to backfilling. If a deadline for connection to the borough system cannot be met, I recommend that borough water service to the home be disconnected so that the sewage will not flow to the beach. If not already accomplished, the owner should clean up the entire area per DEC guidelines to prevent exposure of persons and animals to bacteria and disease that can be conveyed by wastewater. This is especially important in light of the ongoing pandemic. With that, Mr. Mayor, that's the conclusion of my testimony.
Okay, thank you, Mr. Hagerman, and the witnesses you provided. It's now time for the appellant to give her presentation if she has one, and to supply witnesses if she has any. So, Ms. Johnson, you have the floor.
Mayor Jensen, may I give them the oath, please? I'm not sure that they were on the line when we did that originally.
Okay.
Ms. Johnson, can you please unmute yourself and any witnesses that you have on the line as well?
I tried unmuting her as well, Clerk Thompson, and it doesn't appear to have worked.
Okay, yeah, I'm trying to, and it's not working. Ms. Johnson, it is your turn to give your side of the story. Are you? Oh, there we go.
Okay, Ms. Johnson, it's you need the clerk needs to give you heck of a backbeat here.
Boy, I'll say.
And if you have any witnesses, Ms. Johnson, you need to have them be sworn in as well.
Okay, it's me and my mother.
Thank you. If you could please both raise your right hand.
Volume.
And you probably are in the same room. That may not work out. Anyway, do you swear to tell the whole truth and nothing but the truth?
Yes.
Ms. Johnson, is it possible if you and your mother are in the same room, if you could share the same computer, it might alleviate the backbeat issue.
My mom's just sitting here.
But
The phone is echoing like crazy. I'm trying to figure it out.
so, Ms. Johnson, it looks like you have two devices open.
Yes, ma'am. We have our phone open.
That's the problem. One device would be
Yeah,
best.
keeps logging out. So the phone is my backup plan. I lost y'all earlier for like 10 minutes.
I see. Well, maybe the phone could go on mute then or something, because that is the issue. You have two devices open in the same room.
My phone was on mute.
Okay, so it seems like the feedback is gone for the time. So, Ms. Johnson, it's your turn to give your presentation. Are you still there?
So let's see. Yes, sir. Can you not hear me?
Yes.
Okay. Let's see. I'm in Mississippi, and I had asked Mr. Joe Aliberti to step up and be a witness for me, but he was out of town hunting. So I'm going with whatever decision is decided at the end. You know, there's possibility of appealing it to the Superior Court, and that's when I'll ask him to be a witness for me. But let's see. I was just going over, in my letter I stated most of my thoughts previously, but I was just going over the notes, and I wanted to make clear that the septic tank is a working septic tank, and the only reason that there was sewage on the hillside in that moment was because my brother had disconnected the sewage line because our toilet was clogged, and he had disconnected the sewage line, and he got arrested while he was doing that. So it was unhooked, but normally in the last 2 years I have never noticed. I would not condone sewage being pumped onto my hillside. It had just started previous to that, like a day, I think, before Officer Walker saw it. And it was connected to the sewage. That's how it was connected when I bought the home, was from those piping straight to the septic. And it was not pumping into the creek. There's a line going there, but that was just the outflow. The inflow, it was the material, the matter is left in the septic tank. The only reason it was going into the creek when the city saw it was because the connection, the hookup was unplugged by my brother, disconnected by my brother. So I just want that to be stated, that it was just a temporary issue because my brother had gotten arrested while he was fixing it, in the middle of fixing it. So previous to that, I had never seen any sewage, any feces or toilet paper or anything on my hill for 2 years. There was something clogging the toilet. But just let that be known. So I was going over, let's see. I was going over the ordinances and definitions, and I found one that it's the person, and I think that the responsible party is the city, because the project that was put on 15 years ago to hook up the sewage to each residence on Mitkof Highway, the ordinance said that the city had given them 180 days to be up to code with the code of ordinances, and if they weren't up to code, then they would come back and inspect it and then report them to the Department of Environmental Conservation, and they would be notified of the situation. Well, I mean, I think the project was put in almost 20 years ago, and I feel like somewhere along the line, the city admitted that they remembered talking to the lane, 12 or 15 years ago, however long the project was. They admitted talking to the lane, and the lane's saying that they were going to fix it. And I think 7 years later, the lane's finally hooked up to the water, but they never hooked up to the sewage, apparently, according to y'all. But this was all documented. It was supposed to be reviewed by the city within 180 days, and they were supposed to be in compliance way back in 2000 whatever. And now all of a sudden the officer shows up to my house without the proper warrant that the city is required to do, and have a witness or a city borough person is supposed to be escorting them. There's no way that they were on my back porch looking when I gave them permission to go inside my home. They never went onto the back porch then. I had a friend there that was there walking with them, and they never went downstairs on the back porch. They came later on their own without a warrant and without any witnesses or permission from the owner to take these pictures. So, let that also be stated, because I feel like I'm being attacked right now. And I bought this home from First Bank. It was 1 day into going into foreclosure, and which in y'all's ordinance says the person that is responsible for a violation is either the bank if it goes into foreclosure, or the sentence states, I'm just going to pull up the definition really quick, just to be clear. Let's see. Okay. The definition says a person having the owner's permission to occupy the premises for a period of at least 90 days, or any person who created, caused, participated in, or has allowed a violation to occur. I feel like when I bought the home, I was told that it was hooked up to the city sewage and that all was fine. But the people that created, caused, or participated in the problem were the city project performing this thing 15 years ago and not tracking what the outcome was. I mean, I think there's way more people involved in it than just Courtney Johnson purchasing a home in 2018 when the project at hand, I think the project manager was Mr. Hagerman himself, and if he were part of the project manager during that, I feel like there's something in the system that should have red flagged that these people were not part of it. And now y'all want me to get a boat with the equipment to come pump out a septic tank that has been installed. I think the septic tank was installed in 1991, and the city told me that they had documentation of everybody that has ever pumped out the septic, and it is stated that it has never been pumped out. And now y'all want me to pay these huge prices to get a boat in there with the equipment, to pump it out, to fill it up, to then connect to the city sewage, and by excavation, which is quoted $25,000. And I have I've been paying the meter. I've been paying for 2 years now on my bill, the sewer and sewer service, which fluctuates every month by usage. I have been getting charged almost $50 a month for sewer, and my bank, my mortgage company told me that it was all good. So how was I to know? The previous owners knew, and the city knew, which seems more liable for it. My mortgage lady said that she looked back 20 years of paperwork for them and never received any papers from the city saying they were in violation of any codes. So, I think it's just due diligence that this should have been done years prior to me even coming in here. And and they just pop it on me when I just bought the home. So, I'm kind of shocked on how it's coming at me with such force, and nobody else is taking any kind of liability or responsibility for the situation, because I feel like if I'm going to be put on a stand like this and y'all state that this is what needs to be done and there's no buffer, then, I need time to get a lawyer and to present my case also, because I don't have $30,000 to put into the sewage problem that should have been done 15 years ago by previous owners. Also, let's see, the 9.16.030 ordinance, unlawful enumeration. Let's say I did not create, permit, or maintain the problem because I had no prior knowledge of the situation. I had been paying the sewage each month. I was told that everything was up to par. It wasn't until a year later that we cleared the property line that we even saw that there was a septic tank there. We had no knowledge. We were just told it was hooked up to the city, and it was filled in by alder and blueberry bushes, and we had no knowledge that this was ever even an issue because as I said, we were told by the previous appraisal and by Petersburg Properties and First Bank that it was all up to code, everything was great. And it wasn't until we cleared it that we even noticed the septic tank. But still, and still, the city had sent people to come and approve or say that I was in violation of codes the first time they came, and they did indeed walk around the site where they said they did not. They walked around the whole beach line, they walked the creek, and there was no proof because it wasn't happening. It was hooked up in accordance to whatever was before, and it wasn't until my brother disconnected it to try to get the piping unclogged that there was any form of excrement or whatever that Officer Walker says he took a picture of. And let's see, because my brother told me that when he got arrested, he had asked the officers to pass word to me that he had disconnected the sewage and we needed to hook it up again. But there was no word of that. There was just these photos taken, apparently. So, without this warrant that the city requires. Officer Walker, I feel like prejudged or slandered my name for when they came to my house the second time. He made a joke that he thought I was... Yes, sir.
So just please keep to the issue at hand about the abatement for you to fix the sewer, and
Yes, I am.
not personally mention anybody's names and go down that route.
Well, he was a witness that I was able to cross-examine, right? I mean, because I'm just stating they were saying that I knew that I was responsible for this because I knew what I was doing because I was some environmental hippie, but I did not know. That has to go under the code 9.16030. I did not create, permit, or maintain this, and, the police are saying that I am, but I just want it to be known that I had no prior knowledge to this, and until these photos and this second violation, because Officer Walker was with the group of city employees that had done the first inspection, and then he came back on his own the second time. So I'm just stating that. It has all to do with my witness cross-examinations, I guess. So, let's see. Also, the code 9.16.080, abatement appeal to assembly. It states that the assembly shall fix the date immediately following the appeal. Such date shall not be less than 10 days nor more than 60 days after appeal was filed. Well, at this point, it's been 64 days, and so I feel like this appeal, this meeting that we're having, is actually expired because y'all gave in your ordinance, y'all said that there's only 60 days for this meeting to happen, and it's been 64 days. So, it has been almost 3 months that the city came to my house, 2.5 months the city's come to my house, and nothing has been said until I leave my home and come to Mississippi. Is there this appeal? But it's beyond the time frame anyways. It would have been nice if it would have if there was such a problem that, I was contaminating the ocean and the waters, you'd think this would have happened way sooner. But it just drug on until it's actually expired. So, now here we are beyond the date. It just further proves the fact that, the borough thinks that they're immune to their own code of ordinances and they don't have to abide by their own deadline standards. It shows back in 2006 when they said they had 180 days to approve these projects, or they were going to be filed to the Department of Environmental Conservation. And also now in 2020 when y'all gave 60 days for the appeal, and it's been over that. So just, for the record, the borough doesn't always follow their own deadline standards. So, I feel like somebody else should have a little responsibility into this. Let's see. The appeal to the Superior Court after the final decision. So, that will be an option with a lawyer that I hire. What else? Yeah, so if y'all say that I'm not hooked up to the city sewage, but I've been paying these monthly fees and usage has been showing, it's been fluctuating each month. Where is that money? Why am I being charged it if everybody knows that I'm not hooked up to the city sewage? I don't know how y'all would expect me to know anything different if I weren't told this. The city told me to hook up to the city septic, or to the septic tank while we waited for the meeting, but I had argued that according to the Petersburg Code of Ordinances, that it is unlawful to be hooked up to septic when city sewage is possible. So, spend all this money on these temporary fixes when the temporary fix probably should have been fixed 15 years ago and it should be permanent at this point. So, y'all are expecting a lot out of me when I'm just like the scapegoat for somebody trying to cover, their errors on the previous project at hand. Pump out the septic and all this stuff, it's, it's a pretty big project. Let's see. Yeah, the bottom line is, there's no problem with the septic tank itself, but, it should have just been hooked up to the sewer like 10, 15 years ago. And, I don't know if this is even a conflict of interest, that Mr. Hagerman was on the project 15 years ago, and he's going to be making the final decisions with, my build cost, the recovery of costs ordinance, because, I feel like somebody should step up and talk about the issues at hand back when the project was first going on. I've called CCON and gotten dates, and I've tried to call the environmental conservation people because, was it reported to them? Where did it hiccup from there to now for it not to go noticed? Let's see. What else? Yeah, we did not install those corrugated pipes like y'all had just stated. It was like that when we bought the house. I was just told it was hooked up to the city sewage, so we never bothered with anything. It was just like that. Nothing seemed to be flowing out. There was no leakage. There was no problem until, and let's see. And also, I pointed out to one of the city workers when they came the second time, there's a pile of white PVC pipes or whatever in my creek. And, I just always assumed, and it looks like something had been taken apart, like the piping had been taken apart and stacked up in the creek, and it's been there since I bought it. And it just, from every angle, I was told I'm paying for the sewage. I was told the sewage was hooked up to the city. The piping that was disconnected from something is laying in the creek. Everything leads to me being hooked up to city sewage. And, I don't get why now all of a sudden. Because if, how, I just don't understand who's to say that, those pictures that were taken, if there were no witnesses and no warrant and I wasn't involved in the search, I mean, how do I know that that wasn't an animal's poop or somebody placed it there? There's no proof of it, just these pictures that were taken from some time they said they were allowed on my back porch, which, I don't seem viable either. It's like a full form poop. It looks disgusting and it looks,
Okay, Miss
I don't see
Johnson.
how
Excuse me, Miss Johnson.
like that.
Miss Johnson? This is Mayor Jensen.
Yes.
You've covered the same points many
Yes,
times.
I'm here.
Can you hear me? Can you hear me? Debbie,
Yes, I
you hear me?
can. I was covering the different ordinances.
So you've gone over your presentation, and some of the topics in your presentation you've covered multiple times, and you will have time for rebuttal and closing comments. Do you have any new information to present for your presentation that deal with the matter at hand, and that your appeal on this order of abatement? And you've covered that whose responsibility it shouldn't first time. So do you have any new information? Either that or we should move along, I think.
Well, that is the problem at hand, I think, is, I think I covered just the problem at hand, that I don't really necessarily think it's my problem to fix. And I haven't gotten any new information. So if it continues to go further, then, we'll take it to Superior Court and I'll get a lawyer and there'll be new information, I guess.
That's fine, that's your prerogative. So at this point, do you have any new information for your presentation? And if not, I will call on the rebuttal testimony by the building official or Mr. Hagerman, and then you will have time after that to rebut his comments and closing comments by yourself. So please stay on the Zoom meeting, and it just seems like we were being repetitive, so we should have set a time limit for the testimony or presentation before the meeting started, but we didn't. So,
I don't understand what you wanted from me.
Okay, Ms. Johnson, I'm going to turn it over to Mr. Hagerman again for his rebuttal, and then to your testimony, and he will be able to rebut his testimony as well, or his rebuttal. So, Mr. Hagerman?
Thank you, Mr. Mayor. Just a few comments from Ms. Johnson's testimony. I'm not sure how she thinks wastewater gets into the city system, but sending it down to the beach is not part of that equation unless there's a pump system involved. And I never heard her say anything about trying to maintain a septic tank. Actually, I heard her say that she didn't know there was a septic tank down there until recently. And then, of course, she said the whole time that she felt that she was connected to the city system. When she found the septic tank, which she said was connected the whole time, that should have been a big clue that she was not connected to the city. Furthermore, that septic tank, not having been pumped in decades, cannot possibly be working. It defies the theory of a septic tank. Solids build up in one section, and they're supposed to liquefy and go out of a drain field. In this case, there was probably a marine outfall to that tank that likely is not working anymore, because as they fill up with solids, the solids pervade the entire system and plug up. So now she has a discharge from a non-working septic tank going to an open stream on the beach. That is a clear violation. That should not be allowed to continue. The statement about Officer Wachter coming back to the home after the initial permission to search for the other subject, it doesn't make any sense to me either. He clearly had permission. Officer Wachter actually has body cam footage of Ms. Johnson giving him permission to search the home, and he took the photo, a clear photo of a separated pipe with toilet paper and human excrement on the ground. The photo evidence is plain, very plain. She says she did not create or permit this nuisance. As the property owner, it is her responsibility to fix such a problem. It was clearly visible from the back porch, this problem, and therefore she did create it, she did permit it, and it did exist as under her ownership. I think that's all the rebuttal I have, Mr. Mayor. Thanks. Oh,
okay, thank you.
Mr. Bergnoli has a comment.
Can I say something, Mr. Mayor?
Go ahead.
Well, just the only one thing that Carl covered it all, that what we saw, and I think referring to the second time that Officer Wachter came out there, is he came out there at our request, Justin and Dennis and myself, to accompany us on that second investigation. And then the statement I heard stating that black corrugated pipe was always there. It wasn't there when the picture was taken, and that black corrugated pipe looks really new. And I do believe that Patrick, I guess his name is, stated that was he just put that down there as his temporary fix. So that corrugated pipe was not there previously that I know of, because it looked perfectly brand new when we were there, and then the pictures verify that too. So that's the only things I noticed there. That's all.
Okay, thank you. So, Mr. Hagerman, are you done with your rebuttal?
I believe I am. Thank you, Mr. Mayor.
Okay, thank you. Ms. Johnson, it's your turn to speak if you have a rebuttal and then some closing comments. So go ahead.
Yeah, in accordance to in comment to the pipe being new, if you look at the picture that Officer Walker took, the black pipe is on the hillside just south of the pipe itself, coming out of the ground. It was always there. There was a connector part that my brother removed, and it was laying right next to the black pipe coming under the house that went into the corrugated pipe that's in the picture. On the side, if you look at the zoomed out picture, there's the corrugated pipe in the picture just off to the side. My brother had disconnected it, and there's a connector laying right in the stream also. So the pictures do state that. It has been that way since we had bought it. We just reconnected it when the time came, because my brother did let the officers know that I needed to hook it back up, but it was never stated to me, so I didn't know for a day or two, and that's when the picture was taken, was the next day. So the problem, the whole issue is me pumping sewage onto the hillside. Well, it was never pumping onto the hillside. It had been that temporary, that half day that my brother was fixing it, and it is now fixed. It's back hooked up to like it was, and it is not currently pumping sewage onto my hillside. It's pumping into the septic like it had always been.
Okay, thank you, Ms. Johnson. And if that's all you have is the rebuttal and closing comments, now we have closing comments by the building official.
Thank you, Mr. Mayor. I just want to reiterate my recommendations from my earlier testimony. It really appears to me that there's no refuting the fact that there was human waste on the ground, and also now I think we've identified septic tank not being maintained for many years, can't possibly be working right. So in essence, there is untreated waste from the home being deposited on the beach in that stream and then out into the Bergnoli Narrows. So I would ask the Assembly uphold the order of abatement on August 3rd, from August 3rd, and set a deadline for her to connect to the borough's collection system, and also to, if she hasn't already, to clean up the site below her home so that there is not a hazard to anybody that would happen by on the beach. And that's my closing comments. Thank you.
Okay, thank you, Mr. Hagerman and Ms. Johnson for your testimonies this evening. And now we're at the point where the evidence has been presented, and we'll close the public hearing and we'll proceed with deliberations. And it's up to the Assembly if they would like to go into executive session, but I feel we should. Ms. Johnson, the public hearing is over.
Will nobody address the fact that I've been paying for city
Public hearing
sewage?
is closed. You had your chance to rebut.
It's taking connected.
No, it's the public hearing is closed.
I thought I got the final.
That's the process we're using. So now we're going to move forward with our deliberations of the Assembly, what direction we're going to go. The following motion language can, wait a minute, we need a motion to start deliberation. Clerk Thompson, I've only done this once before, so you could clarify what the next act, part of the procedure should be.
All right, let me read it too here real quick, because it's not...
Yeah, I know we need to deliberate and then come up with a written decision.
After the evidence, so we're on J. After the evidence and argument has been completed, the assembly shall close the hearing and proceed with deliberation. So the hearing is now closed.
Correct.
And so a motion to... I think you only need a motion if you are going to deliberate in private session. If you're doing it in public, you don't necessarily need a motion. Well, I guess you'll need a motion to discuss it if we're going to do parliamentary procedure.
Right, so the way I'm reading this procedure that you have given to me in print here is a motion to deliberate on an adjudicatory proceeding as permitted under Alaska Statute 44.62.310, parenthesis D, parenthesis 1. It is advisable to note upon the decision in public session if deliberations have been occurred in closed session, which they haven't. So I think we need a motion to deliberate this proceeding.
Yeah, Mr. Mayor, I missed the last part of that.
We're at the point now, Member Mucci, where the evidence and argument portion of the hearing has been completed. Now we have chosen not to go into executive session or closed session for the deliberations, so we need a motion to deliberate on an adjudicatory proceeding as permitted under Alaska Statute 44.62.310 D, parenthesis 1.
Mr. Mayor, just a quick, as a point of clarification, that using that statute only applies if it's being done in closed session. Is that correct, Clerk Thompson?
Yes, that is correct.
Okay, so that we don't need to adhere to that state statute, we just deliberate?
Correct. I think maybe just a motion to whatever someone wants to make a motion so you can start deliberations on this appeal. Yes.
I will make that motion, Mr. Mayor.
Okay, has that motion been made by Member Mucci to start the deliberations on this hearing?
Yes, it is.
Is there a second? Is that Member Stanton Gregor?
Yes, sir.
Okay, thank you, Member Stanton Gregor. So now what our goal is the Assembly is to issue a written decision on the appeal. The written decision shall contain findings of fact, and if the Assembly affirms that a nuisance subject to abatement exists, an order based upon its findings directing the abatement within such time period and upon such terms and conditions as it may prescribe. Then we have to vote on what we come up with. And after that, then we direct the building official to prepare a draft written decision for the Assembly's consideration at the next meeting, because now we're acting as a court in a sense. The decision shall also state the potential consequences should the nuisance not be abated as directed. So, and then that written decision will be mailed to the appellant or personally served. So, I would think as findings of fact, we could use Mr. Hagerman's support order of abatement and the reasons they issued that.
Mr. Mayor?
Member Lynn.
Thank you. Looking at the points that Mr. Hagerman made in his presentation and comparing that to those of Ms. Courtney, I don't see anything that was presented that would lead me to change any of the items that were in Mr. Hagerman's presentation. That is, and as was said, that is the responsibility of the property owner. And I didn't see anything in the presentation that would lead me to believe that it was a responsibility of a third party. Thank you.
Thank you, Member Lynn. Is there any other input? I agree with Member Lynn. I think we're on the same page as using Mr. Hagerman's presentation as our findings of fact.
Mayor, may I chime in?
Member Stanton Baker.
Thank you, sir. Yes, I found no compelling evidence to do anything, in my opinion, other than uphold the order of abatement, and I would suggest setting a date of 30 days from written judgment to complete that.
Okay, Member Stanton Baker, would you be willing to make that 30 days start from after the assembly approves, if they do approve
Yes, sir.
Decision?
Absolutely.
So that would be, end up like being December 2nd, so.
Yep, that works for me.
Okay, thank you. Any other input?
Well, I would second Member Gregor's motion there.
Okay, and also, I guess we have a motion on the floor. Member Lynn, I believe if your statement was in the form of a motion to use Carl's findings of fact, so should we address that? And then make it 30 days? Can we put those in the same motion, or?
I would be willing to do that, to follow Carl's finding the fact and to look at fixing it 30 days from, I think it would be from providing the final decision.
And that will be done by the assembly, which is November 2nd, potentially. Okay, so is there any discussion on the motion, or is there a second to that complete motion to use Carl Hagerman's findings of fact and make the deadline 30 days from after the assembly?
I'll second that, Mr. Mayor.
Okay, second by Member Stan Gregor. So discussion on that. What we're talking about is, go ahead.
There's the point of clarification. If I'm hearing this right, the motion is to uphold the abatement order, the date 30 days after the assembly rules on it, and using Director Hagerman's finding of facts as evidence. That's Director Hagerman's presentation as a finding of fact. That's a synopsis of of the motion.
That's the way I understand it.
Yeah, you to clarify.
No, that's good. That's good. Any other questions or confusion over what we're doing here before we vote on this? And once we vote on it, then I will direct the building official to prepare a draft written decision for the assembly. Okay, see no other comments or input by assembly or by the people on the board here, appeal board. Clerk Thompson, will you please call the roll?
Yes. Chelsea?
Yes.
Dave?
Yes.
Jay?
Yes.
Taylor?
Yes.
Mark?
Yes.
Jeff?
Yes.
Bob?
Yes.
Thank you.
Okay, so it was a unanimous vote to use Mr. Hagerman's presentation as the findings of fact and to put a 30-day time limit in this letter, draft written decision, and that was voted on. So I, as the mayor, direct the building official to prepare a draft written decision for the Assembly's consideration at its next meeting, November 2nd. The decision shall also state the potential consequences should the nuisance not be abated as directed. So, Mr. Hagerman, if you would do that for us by November 2nd, that would be great.
I will do that, Mr. Mayor. Thank you.
So I guess I'd entertain a motion to adjourn.
So moved.
Second. All those in favor say aye. 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 Opposed?
Aye.
None. It's unanimous decision to close the hearing. Thank you.